We meet next Wednesday, again at 2, but we are going to utilize what was a part of our request to Parliament to be able to conduct these meetings virtually. So that next Wednesday, those of us who would like to be here in Parliament can be here in Parliament. I will try to be here, but those who would rather to be at their desk can join us. But we will ask you to at least join us, not only video, but when you want to speak, you turn on your mic to speak or to ask questions. So we have to be sure that when we start, at least next week, Wednesday, we have a quorum. But especially in light of the various restrictions we are now enduring, I think if we can go virtual for future meetings, we'll do so as much as possible and reduce the number of persons actually gathered. Now, I did indicate to the contributors that, as was suggested by Member Bunting, we're not going to go through the contributions fully. So we have asked both MOCA and MNS to highlight the main issues in their submissions, and then we'll get a response from the NIDS team and also for all members who would like to ask questions or to elaborate. So after the presentation and the response from NIDS or any time in between, members could, make comments or ask questions as the case may be. Immediately after MOCA and the Ministry of National Security make their presentations and responded, we have indicated that we have in the region of almost 100, 96 to be exact, written submissions sent to us. You have seen some of these submissions. Many of them just make a point or just ask a question. But as I indicated last week, we are going to at least indicate openly that we have got, these contributions from persons who have written. So we have identified about 20 of them that came in. We usually just asking a question or making a comment. So after the MOCA and Ministry of National Security presentation, time permitting, we'll try to go through as many of these 20 as possible this afternoon. And as we go along, we'll try and cover most of these 96 contributions that were sent to us. So most of them, I don't expect that they will want to appear here or even virtually. They just ask one or two questions or make a few comments. So we just want to acknowledge them and to respond to them as best as we can. Now, we don't want to fall too far behind, so I did ask a couple of members to have a look at the minutes. So the reading and confirmation of the minutes for January the 5th, 5, 13, and 14. And if I've asked Member Sibbles and Smith to examine them carefully for me. So if there are no corrections, we're going to ask for confirmation of these minutes. But bear in mind, if members should read them at any time and find any corrections or changes, we can always ask for recommittal, okay? All right, so Member Sibbles and Marsha, were you able to read them? Can you move for the confirmation? So confirm and seconded. So the minutes of the 5th, 13th, and 14th are now confirmed, but as I indicated, if at any time members should read them and find any need for recommittal, I'm quite prepared to recommit them. But at the next meeting, we probably have another few more to put on the list and to be circulated. And any matters arising, did you, Member Sibbles and Smith, did you see any matters arising that you would like to raise? No, fairly good. All right, thanks very much. So having dealt with these matters, we are going to ask now the Major Organized Crime and Anti-Corruption Agency to make their presentation. Could you please just announce who you have with you? turn on your mic.
Mr. Chairman, good afternoon. The members of this honorable committee. My name is Arth Dunkley. I am a Deputy Superintendent of Police at MOCA. Along with me is Lieutenant Colonel Patrick Cole and Mr. Nigel Park, both legal representatives here this afternoon. The intention of this submission is to identify areas in which this legislation can be made more robust in its application and scope, and also to indicate areas in which the legislation may enhance national development. The agency believes that this act will have great utility in improving efficiency in governance. From a law enforcement perspective, lawful access to the information contained in the database should, it is anticipated, be an asset to the conduct of investigations. With such a system, the ability of assuming multiple and false identity should be decreased significantly. The use of biometrics, for example, should assist to curtail these practices. The bill proposes that enrollment in NIDS is voluntary, and given this reality, it is not unlikely that individuals involved in nefarious activities may decline to register, or in fact, deregister if they were previously enrolled. Section 14 states the authority shall cancel the enrollment of an enrolled individual if, according to subsection B, the individual requests in writing to the authority, accompanied by the national identification card issued to the individual, that the enrollment be cancelled. It is recommended by us that even if enrollment is cancelled, consideration should be given for the non-expungement of the identity information from the national ID database. At the minimum, some basic data, example names, date of birth, addresses, should be retained and an audit trail maintained, highlighting date and reason for expungement. Next point. Section 25, which makes reference to an accredited third party to whom information from NIDS may be entrusted with an individual's consent. It is recommended that the term an accredited person be defined or expounded upon in the Act. Next point. Regarding disclosure of identity information, Section 24, subsection 2, permits the Commissioner of Police, without notice, through application to a judge of the Supreme Court, for an order to the authority to release information for a specific purpose. This, we found, is a very useful and prudent insertion. However, given that accessing the data in this manner is required for prevention, detection, and investigation, as well as for national security, according to Section 24, subsection 20, subsection A, B, purposes, then other law enforcement entities may also require the information. Hence, the head of those entities should also be considered. Example, the Director General of MOCA, the Chief Technical Director of the FID, our Financial Investigation Division. Next point. There is currently a heavy reliance on information provided by the Register General's Department. Given that, according to the Act, the database will be subsumed by NERA, consideration should be given to the process of acquiring information from the department. Currently, MOCA, and to the best of our ability, our knowledge, other law enforcement agencies obtain information by applying to the CEO of the RGD. It is suggested that the bill indicate if that process will remain, given that the data being sought would be data that does not comprise parts of the NIDS, or follow the stipulated protocol in the Act for obtaining NIDS information, which by virtue of the current formulation would preclude MOCA from making an application. Next point. It is highly recommended that there is continuous vetting of all staff members, especially those that will have access to the data records, electronic or physical. This is based on the sensitive nature of the information that will be contained in the NIDS. Next point. There is no provision at section 19, subsection 3 for unauthorized possession as an offense. This could pose a challenge where an individual is found with NIDS data in either physical or electronic format without a lawful excuse. There is also no mention of the computer as a repository or being incidental to a crime. It is recommended that an offense of unauthorized or unlawful possession, simpliciter, be considered, and it should cover both physical and electronic records. Next point. Subsection 23, subsection A, C, D, E, F, G, and H refer to a generic outline of cybersecurity and information security standards. It is suggested that there is also an outline of adherence to or mention of international standards with defined security controls. These standards, while not an exhaustive list, is critical for data management. Two recommended standards that relate to data privacy and data security are ISO 27701 and ISO 27001. They are described as follows. 27001 relates to the way an organization keeps data accurate, available, and accessible only to approved employees. ISO 27701 relates to the way an organization collects personal data and prevents unauthorized use or disclosure. These adherences serve to prevent the bill's itemized standards from becoming outdated as best practices evolve and new technologies become available, as well as being general data protection regulation compliant. Next point. Section 23, subsection D and I. The reference viruses falls under the category of malware and need not be separated. It is recommended that the reference to viruses and malware be rephrased to say malware, including viruses, ransomware, Trojan, worms, etc. Subsection. Next point. With respect to section 23, as part of the security of information, there should be consideration for a cyber incident response process. For example, where a breach occurs during regular operation and outside the control process of the inspectorate, as outlined at section 23, subsection 3, subsection F. Next point. A protected computer is defined as belonging to a class of computers or used by a certain body as outlined below and is used directly with A, the security, defense, or international relations of Jamaica, the existence or B, the existence or identity of a confidential source of information relating to the enforcement of the criminal law of Jamaica. C, confidential educational materials such as examination materials. D, the provision of services directly related to communication infrastructure, banking and financial services, public utilities, public transportation, or essential public infrastructure, such as hospitals, courts, toll roads, traffic lights, bridges, airports, and seaports. And E, the protection of public safety, including systems related to essential emergency services, such as police, fire brigade services, civil defense, and medical services. It is recommended that the servers that host NIDS database and other related hardware be regarded as protected computers. Section 9, subsection 10, subsection A of the Act states that a person who commits an offense under subsection 9 shall be liable on conviction before a parish court to a fine. If our recommendation is accepted, it would therefore be consistent with the existing Cybercrimes Act of 2015, where the applicable sections in regard to protected computers state that where an offense is committed, the offender shall be tried an indictment in the circuit court and shall be liable upon conviction to a fine or imprisonment. To effect this provision, a consequential amendment to the Cybercrime Act of 2015 would be necessary. That ends my submission.
Thank you, Superintendent. But the last part, look at, you have the Act with you? Section 910B provides an alternative. So it's not only the parish court. You see 910B, you refer to A as being in the parish court, but it could also be in the circuit court under section B. Agree? Yeah.
Agree, Chairman. Yeah. I believe what the committee could consider further is whether it wishes to have an alternative, given the seriousness at which it wishes the database.
So you don't want the parish courts to deal with it at all?
It is something the committee could consider, because when you, depending on where you place the offenses and the jurisdiction, it sends a statement as to how it ought to be treated.
No, but I'm not denying that putting it in the circuit court emphasizes the seriousness of the offense. But don't you think that there could be minor breaches that you wouldn't want to tie up the circuit courts with?
Certainly, Chairman.
So that is why the alternative with the parish court. No, I agree with you. If the breach is very serious, it should really go to the circuit court. So a higher penalty or imprisonment could be imposed. But don't ignore it could be a minor breach, in which case you don't necessarily want to tie up the circuit court. So I just mentioned that, which is something that the members could, we could make a decision when we have to look at it, okay? And if members don't have any immediate question, we could ask the NIDS team to respond to the submission. Okay.
Yes. Okay, thank you, Chairman.
Sharika.
In relation to MOCA's recommendation to retain some basic data, such as name, date of birth, address, if enrollment is cancelled, and also that an audit trail be maintained, consideration may be given to this recommendation by the committee.
And to the extent, to the best of my knowledge, to Superintendent and the MOCA team, I think where we think there is fraud involved, that the Data Protection Act allows us to retain some of that material. Isn't that so, Sharika?
Yes, you're
right.
correct, Chairman.
So we agree with you, Mocha, especially if we think the cancellation is an attempt or appears to be some fraud or dishonesty. The Data Protection Act allows us to retain the data, but not necessarily in the active database. But we retain it because, you know, once they agree to deregister, we take them off the active database. But we will retain information, as you pointed out, so that for checking, because it could be an attempt at fraud. Agreed?
Certainly agree, Chairman. The only point I would...
Sorry. Could you yeah,
I'm sorry, my name is Nigel Park.
Yes. Yeah.
My name is Nigel
Parks.
P-A-R-K-E.
Okay. Agree. Okay, go ahead, Mr. Williams.
Yes, sir. I just wanted to raise the issue. If the retained data is not kept in the active database, when a check is being done to see if a person has previously registered, it's just to ensure that that retained data can be cross-referenced.
No, I suspect, I don't know the actual mechanism, but I suspect it will be in the archive, say, that can be checked on. But the point is that if someone should check with the NIDS, if this name is on the database, they can't say yes because the person has deregistered. So you're going to take it off the active database, but it will be kept. Okay? Okay. Continue, Mr.
No, before we move from this point, I'm really trying to understand what is the purpose of this recommendation. Is it just for audit purposes, or there is some there's some value for maintaining the what you refer to as the basic data?
Well, if we could revisit the point made by the chairman that where there's a suspicion of fraud, the database should have the capacity of eliminating persons who appear, at the very least, based on the information submitted for registration, to have registered previously and having been deregistered, especially if the view is formed that it is the same data, perhaps accompanying a different name. So date of birth, place of birth, other particulars are the same, but it is attached to a different name.
So the purpose of this is to identify potential cases of fraud. Is that the?
I think that is one use that it can be applied to.
But given that the principle, or one of the principles of the Act, as established in the Supreme Court ruling, is that your registration is voluntary. If by virtue of 14.1b, the individual requests in writing to the authority that the enrollment be cancelled, should that not enable them to the position that they would have been in if they had not opted to come in the first place?
I agree with you, yes, because of the voluntary nature of the registration, but I believe from a perspective of the database being able to ensure its credibility, that there needs to be some sort of resource left available to the database by which it can authenticate as best as possible information being received. I believe Colonel Cole may have some further elaboration.
Yes, Member Bunting, we have to be realistic in how the NIDS can be used and utilized by persons who have nefarious intentions. We have to understand that a person who wants to commit fraud could perhaps, by some means, obtain an identity which is backed by documentation which checks out. The person commits fraud, then applies to be deregistered, and that identity may not be available to be cross-referenced by the investigators because that person will almost disappear from the system. Because we have to be realistic that persons who intend to commit fraud, the NIDS database is very attractive to them as well, because they will try to come under the umbrella of the NIDS brand. So we have to be very careful that we anticipate and be 10 steps ahead of persons who may decide to commit fraud, and to ensure that if there's a case that is being pursued, the paper trail doesn't disappear. So we have to find a methodology where we can preserve some information that if you're investigating something fraudulent, there is a possibility that you can get that assistance.
Let me expand a bit, Minister Bunting, on this. If the person deregister, for all intents and purposes, the person is off the registry. But bear in mind, when he registered, he got an NIN. That's a NIN number. If he tries to re-register again, he has to get back that same number. Now, he's not on the active registry, but there could be an archive, or for instance, when he deregister, he has to return the identification card. So to the extent that that identification card is still available or in the possession of the NERA, that's the NIDS authority, then once he tries to re-register again, he gets back that NIN. But for all intents and purposes, he will be removed from the active database, so that to the extent that the police ask for information, say, for example, about that person, he's not on the active database. Or if an institution asks for information about that person, he's not on the active database. Okay? So for all intents and purposes, you're right. He has deregistered from the database. Okay? Okay, continue.
But I understand the distinction you're making between an active and a sort of archived database. But I'm just interested in because obviously the MOCA representatives are trying to anticipate how people will abuse the system fraudulently. And I confess I had not anticipated this deliberate potential for abuse, where persons who are going to use the system, or potentially try to use the system to create a strong false identity, which will actually facilitate them in committing fraud, because the user or the victim, the target, will see their NIN as something very strong in terms of security protection. Having committed that fraud, they don't want to
change their identity.
Change their identity. So they apply for cancellation of their enrollment. And so if they are now removed from the system, or even the active system, law enforcement now searching for them would have a difficult time finding them. So I must confess I hadn't anticipated this potential abuse, but it would be a real
the imagination,
a real case that we have to guard against.
Absolutely.
You know, and I think it has some implications. They use the word expungement, but I don't think a cancellation would be would be analogous to an expungement, because when you expunge, it's as if it had never happened.
That's right.
But a cancellation would not be equivalent to an expungement, because once you keep them in some archived record that is retrievable, then you would always have a connection to that identity. Once it's created, it would never disappear completely. It would come off the front page, but it would be, you would be able to retrieve it in a perhaps something that is, you know, you get a warrant for a judge or something like that to go after it.
Okay, thanks, Minister Bunting. Member Bunting. Minister Camilla Johnson.
Thank you, Mr. Chairman, and my apologies to you and to the team for my lateness. I just wanted to say that I'm so thankful that although it had not crossed the mind of Member Bunting, that thankfully it had crossed the minds of the technical team that has been working on NIDS, and that the drafting of the legislation and the framework around which it had been determined that the framework for cancellation would have to be such as is required or such as is necessary for compliance with the Data Protection Act and for the retention of the technical credibility and the security of the database and its identifications, the contents of it, so that it has been contemplated, and it is in fact not only part of the technical and security framework, but it is indeed permitted under the legislation as currently phrased. This is why the reference is specifically to the prevention of fraud, because the Data Protection Act has a specific requirement or specific parameters for what processing is permitted and how processing is defined. I'm sure Member Robinson is well seized of those particularities as well. And therefore, I really find it to be one of the circumstances which bring me to congratulate, or let me not congratulate, but rather to commend the technical team, because they really have been trying to think as broadly as possible within the time that we have been given to anticipate and indeed prepare for such nefarious actors.
Right.
But thank you, Mr. Chairman.
Thank you very much, Minister Jansen. Ms. Heben Williams, continue, please.
Okay, with respect to MOCA's suggestion at Clause 23 to mention international standards with defined security controls, Clause 23, which speaks to the security of information, was intended to be read in conjunction with Clauses 5, 6, 9, and 33. The details of cybersecurity and information security standards would be specified in subsidiary policies, processes, and protocols, whether internally or in regulations as required. And this will also ensure that the principal legislation does not need to be amended to keep in line with the fast pace and constant technological changes, while enabling fluid risk management, which is anticipatory and reactive as may be required. The NIDS project is utilizing the National Institute of Standards and Technology Cybersecurity Framework, ISO 27000 series, for information security, and the COBIT 5 for governance support to manage enterprise risk. In relation to MOCA's recommendation to rephrase the reference to viruses and malware in Clause 23, consideration may be given to this recommendation, and the NIDS technical team is suggesting that it be changed to malware, including viruses that are internet and intranet based.
Secretary will note that point, that you will support the recommendation, right? Okay,
Yes,
good.
Chairman.
No problem. The members will consider it at the appropriate time. Go ahead, continue.
With respect to MOCA's suggestion to consider a cyber incident response process, this will be managed in the NIDS incident response policy, which is an internal risk management document which would not be captured in legislation. With regard to your recommendation to regard servers that host NIDS database and other related hardware as protected computers, the committee is also, well, this matter is also recommended for the committee's consideration by amendment to Section 9.2 of the Cybercrimes Act via the 4th schedule of the bill. With respect to the recommendation to consider the Director General of MOCA, Chief Technical Director of FID in Section 24.2, consideration may also be given to this recommendation.
Apart from that, suppose the recommendation was the definition of an accredited person. Suppose MOCA, in the definition of an accredited person, we include MOCA, FID, and such other person as the NIRA, that is the authority approved. Would that be sufficient, rather than adding those two entities to Section 24.2? I think it's important. Yes, Ms. Facey.
Good afternoon, Chair, members, and colleagues. We would not be in support of that because we don't believe that we should simply add anyone unless it is that they have been able to demonstrate the particular standards that we require, whether or not they're government agencies.
No, so the point I'm making is the accredited third party could well be one of them. So what is being suggested by MOCA is that a definition of accredited person could be put in to say such person as authorized, or is that implied from this? It's implied accredited person, whoever NIRA supports CPC?
No, well, it's already referred to there. The process for accreditation is to be prescribed, so there's no need to go and define accredited, because the process for accreditation will be prescribed in regulations. Okay,
Mr. Parks? So what we are saying is that in the regulations which will be forthcoming, the definition or how an accredited person or institution would be prescribed. I think, you see, although we put in a commission of police, I think we have to be very careful that we don't want this act to appear as if it is for security purposes. Right? Because it isn't. This is an act of identification, but to the extent that the security person needs verification, not access, verification of, say, address, name, facial recognition. These are verification that the NIRA will be able to supply. Okay? All right. Go ahead,
Mr. Chairman, one question.
Yeah, sure.
If it is that we have created an environment where MOCA is independent and has particular roles which are pretty much unconnected, they don't have to go to the Commissioner of Police or anyone for permission to do X, why then would we need them to seek accreditation when the legislative environment that we've created says to me that they are supposed to be independent and can function in that way?
I don't think, Minister Morgan, that we are saying that they shouldn't get accreditation. I think the accreditation could be very easy. But we don't want to start listing the number of institutions that can apply without more. Because then if you say MOCA and you say FID, why not Bank of Jamaica, for example? Right. But we're saying it will be in the regulations.
I think what the member is saying, Minister, is that in 24, where the Commissioner of Police is given the opportunity stated that that agency, if I can use that term, to make an application to to ex parte application for information. I believe that what Member Morgan is getting at is whether MOCA can be placed in that particular section. That is how I am understanding what he's saying. And that he does, and that they don't have to apply for to be accredited.
Could we put that question to be discussed by the committee? Okay?
I think.
Okay, we leave that issue to be discussed by the committee.
Mr. Chairman, I support that position as well, particularly since MOCA may have to be investigating the police, may have to be investigating theoretically the Commissioner of Police. Why should they have to? Because in any event, they have to go to a judge of the Supreme Court to make the case. It's not as if they can directly download the information. Whether the Commissioner of Police, the head of MOCA, or the Chief Technical Director of FID, they would all have to go to a judge of the Supreme Court with an application.
All right.
So I don't see anything
Let's
lost.
not come to a conclusion as yet. We will leave it for further discussion by the committee. Okay?
Thank you, Chair. Just to point out that the accreditation is a different thing from disclosure. Accreditation is for specific purposes. Disclosure is a higher level, which goes to detection of crime, investigation of crime, etc., as well as in the national interest. And when we go further, you will note that we did indeed indicate that consideration may be given for MOCA and other.
Okay, because this is exactly the point that the members are making. Yeah, good. Continue, please.
We have no further comments.
All right. Are there any issue you would like to raise, MOCA? If that means so, the committee needs go ahead, Mr. Pan.
Yes, Chair. I'm just curious as to whether the technical team had consideration for the creation of the possession simpliciter offense as it relates to the unauthorized possession of NIDS data. Because the section that references the offenses around NIDS data doesn't explicitly speak to unauthorized possession of that data.
Yeah, but Mr. Chairman, there's already an offense under the Law Reform Fraudulent Transactions Special Provisions Act, which provides for, which makes the unexplained possession of personal identity information an offense, a criminal offense. So why would we have to reproduce that in this bill?
Any response?
I do take cognizance of Member Bunting's reference to that offense, but it just seemed curious that every other permutation in relation to the abuse or misuse of programs, data, attendance systems appear to have been covered within the act under consideration. However, there's no mention of unauthorized possession. We think that the opportunity should be taken to explicitly indicate this in this legislation rather than leave it to a cross-reference to a different statute to treat with an offense that originates from the unauthorized possession of data from the NIDS database.
Okay. All right. Any other issue you'd like to raise or respond to, Ms. Mocha? If there are no other issues, we want to thank you very much for your participation. And as you can see, a number of your issues you have raised will be given further consideration by the committee. You don't have to leave. You can remain, as I say, but feel free to stay or leave, as the case may be.
Thank you, sir.
We're going to go to the Ministry of National Security Please, Ministry of National Security, as we intimated to you, we're going to ask you to just highlight the issues rather than go through word by word, okay? So, because we're going to give you 15 minutes to highlight all the issues, and then we respond, okay?
Okay. Good afternoon, Chair, committee, colleagues. I'm Courtney Williams, Permanent Secretary, Ministry of National Security. With me is a Senior Legal Officer, Ms. Kamika Cookhorn, Michelle Lemon, and Christina Bourne. So they are our policy people who would have dealt with most of the issues surrounding the NIDS bill. Chair, we had provided a comprehensive set of written comments, and as indicated, I am not going to go through each of them at this stage, which would be unproductive, but I will just supplement those comments with a few brief remarks. So in compiling our comments on the bill, we had assessed and cross-referenced the provisions of the National Identification Act, which was held to be unconstitutional by the Constitutional Court. We cross-referenced that with the instant bill. In light of the ruling by the Constitutional Court, the National Identification and Registration Bill 2020 was proposed. Upon carefully scrutinizing same and taking into consideration the changes which were effected, I must say that the bill on the face of it proposes to introduce another piece of government of Jamaica identification where citizens and persons who are ordinarily resident in the island may opt to utilize in the absence of the consequences under the previous proposed act. In the review and cross-referencing exercise undertaken, there were certain considerations that we think will enhance the acceptability while retaining the robustness of the NIDS. And I'll just mention three of those considerations, Mr. Chair. The first one relates to the compulsory taking of biometric data coupled with a criminal sanction for non-compliance. Under the proposed legislation, the individual will now be advised that registration is voluntary. Therefore, on the face of it, the compulsory aspect has been removed. Consequent upon the changes, the bill will not bar any citizen or person resident on the island from accessing services in the event that the decision is taken not to participate in the scheme. Further, there will be no restriction with respect to accessing public service in the event any citizen or person ordinarily resident in the island has taken the decision to participate in the scheme. The second consideration I want to mention is just a question of, does the new legislation have strong and adequate safeguards for the protection of the data? In the court's judgment, the court was of the view that there must be strong and adequate safeguards for the protection of the data collected. Section 23 of the bill with regards to the security of information of this proposed legislation has addressed this issue by placing the onus on the authority to ensure that the databases are kept in a secure manner and that confidentiality of the individual is preserved. The third consideration to note here, Chair, relates to the sharing of biometric data with third parties. The court had held that the removal of the right of the person to decide with whom he or she wishes to share his biometric information is a violation of the right to privacy, unless exempt by provisions of the Charter are shown to be demonstrably justified in a free and democratic society. Now, Section 24 of the proposed legislation has addressed the disclosure issue by again placing the onus on the authority not to disclose identity information stored in databases without the consent of the individual, except in specific situations. Furthermore, judicial oversight is a requirement before there can be any non-consequential disclosure of information, as applications will have to be made to the Supreme Court judge, supported by affidavit evidence. Additionally, pursuant to Section 25 of the proposed bill, the sharing of data with third parties can only be done with consent of the individual. Now, just to mention a few of the points that we had made in the submission. As I had said, it was a pretty comprehensive set of comments. I think we had almost close to 40 points that we had submitted, but I will just mention a few here. And one point relates to definition at clause 4.4a. There are definition of ordinarily resident. And this definition here isn't strictly consistent with the Immigration Restriction Bill or the Aliens Amendment Bill, wherein those acts use an ordinary resident in Jamaica for person who continuously reside in Jamaica for 3 or more years. We think to remove any inconsistency or confusion, in the NIDS bill, rather than referring to ordinarily resident, which would not be the same thing, have the same meaning as in the aliens or the immigration restriction bill, they could just refer to resident in Jamaica. Another point, the Chair, in terms of clause 5, and we're looking specifically at 5.4f, in relation to we think this could be reformulated to say that the authority could seek ministerial approval before entering into arrangements. Because as structured here now, it is saying the authority could enter into any arrangement. So we had proposed and recommended that they should probably seek ministerial approval before entering into such arrangements. One other point which I would just want to highlight here relates to, in terms of enrollment. And enrollment in light of the fact that subsections 4 and 5 make a distinction between an individual and the person who applies on behalf of this individual. We're just querying whether the term individual in section 7 and 8 excludes the applicant. And so we think it would make sense if where we have the individual, which could recommend inserting the words "are applicant," so it would say the individual or applicant, because this section speaks to someone applying on behalf of the individual. So we think that point could be made, that adjustment could be made to remove any ambiguity there. And the final point I'm going to make here relates to subsection 5, staying still on enrollment, where it speaks to, it provides for an individual who is an inmate at a correctional institution. Now, it doesn't mention the word, it doesn't refer to wards, because in the Correction Act, an inmate is separate from a ward, because wards would be those held in juvenile correctional centers or juvenile remand centers. So we think we would need to make that actually introduce the word wards, so it would speak to inmates and wards, just to make sure that we are not leaving out those under a particular age who would not be in correctional facilities where they're classified as inmates, but those wards that would be in the juvenile centers. Mr. Chair, I'll just stop here. As I said, it was pretty comprehensive. So
the next one you see, number 11. How would you justify the mandatory enrollment of inmates when it's a voluntary system? And what would be the justification? I mean, I saw it and I said, how would you justify a mandatory enrollment of the inmates? In fact, it would almost seem like additional punishment to some of them.
No, that's a point, Mr. Chair. I can accept that.
Okay, I mean, I just saw it and I thought I would ask you, because if there was some justification I could buy it, but in a voluntary system, the fact that a person has service time and is being released back into the society is not a justification for saying you must enroll. He still has the option, as the case may be, so thanks. All right, if there are any questions from members, then we could take it, and before the NIDS team, feeling the NIDS response. Who's going to do it? Ms. Facey? Yes.
Thank you again, Chair. From what I recall hearing a while ago, P.S. Williams basically looked at the application, and he also looked at the concern regarding the wards. And also, well, you just asked about the mandatory enrollment. Is there anything that I'm missing, P.S. Williams, that you, okay. All right, with regard to the replacement of the term ordinarily resident with the term resident, we would not be able to legislate based on bills. We have to legislate based on existing legislation. Also, I'm going to refer to the CPC with regard to this, as this is really a drafting issue, the ordinarily resident versus resident. Yeah. Through you, Chair.
What the definition of ordinary? Yes, the definition of ordinary resident is already controlled in the bill by in clause 4.4. So that that is the provision that would govern how it's to be interpreted in this bill.
Go ahead.
Thank you, CPC. As it relates to the child consideration, well, we would refer to the CPC with regard to this, because it was under our understanding that, well, we did not see a definition of wards. There is, however, a definition for child in the Corrections Act and the correction rules, as well as the fact that the Child Care and Protection Act speaks to children being put in facilities where they have committed certain offenses. And there is also a definition as it relates to young inmates, and the Corrections Act itself does speak to juvenile remand and juvenile correctional centers. So from that perspective, if there is any further need for elucidation, we, through you, Chair, would again refer this to the CPC.
I didn't get that last point. What's the last point?
Oh, I was saying, should there be any further need for elucidation, we would refer to the drafting expert, the CPC, through you.
CPC?
Yes.
Correctional institution, as defined in the Corrections Act, includes an adult correctional center, juvenile correctional center, remand center, juvenile remand center, a high security juvenile correctional center, and a pre-release hostel. So young inmates would be covered under that definition, and also in terms of children who are in the care of other facilities, that will be covered by the provision in subsection 4A2.
Okay, is that okay? Go ahead, continue. Continue,
Those were the only two areas that
you feel
the MNS indicated, but we could bring, there were certain other areas that had already been looked at,
right.
Which maybe we want to.
P.S. Williams, you can see that a number of the points you raised have already been dealt with. For instance, you notice the cancellation point, and most of the points have been dealt with, so that we don't want to go over everything. But unless you have any particular area that you would want to ask the NIDS team or the member to, you would like a query. Members, do you have any questions to the Ministry of National Security and their presentation? You're okay, P.S. Williams? Or you?
Mr. Chairman?
Yes.
Just returning to that suggestion of the compulsory enrollment for convicted persons. Is this suggestion a way of, in a sense, replacing the Criminal Records Office? Because we do have mandatory enrollment of their information in that database. and it, with the provision for expungement after a certain period of time, depending on the offense. But it would seem to me that this mandatory enrollment would, in a sense, replace the Criminal Records Office, or the need for the Criminal Records Office to...
No, I hope not. Right. Okay, I don't think they're pursuing that point anyway, okay? All right, so any other point, P.S. Williams?
Hello. The other points that were of concern to us, some of those were raised by MOCA. Right, so I don't think at this point we want to flag those and to spend any more time on those. So, and as I said, thankfully, and we're grateful that the team, having reviewed those points that we had made, those comments we have submitted, have, if my understanding is correct,
thank you,
have taken them on board.
Thank you very much. So thank you, MNS, for your submission, and we are going to be here for another half an hour to an hour. It is up to you whether you want to remain. There are some interesting points raised by a number of contributors who have sent in, questions. And what we plan to do, members, over the next half an hour, there were a number of other contributors were down to make presentation, but amazingly, a number of them dropped out at the last moment because of the COVID. No, one or two may have been, some of their presenters may have been in quarantine, okay? And so they asked to withdraw. And then when we tried to get other presenters, the notice was too short. But as I intimated to members, we have about 90-odd contributors, and having asked the public at large to make contribution, then it's only appropriate that we should at least indicate to these members that acknowledge that they have their issues will be considered. Members, we did circulate a list of those that we're going to touch on. I am not going to call the names of the persons. I will just refer to their initials, okay? And these queries came in by email. And the first one is from ZB. Okay, ZB from a Gmail account. And the question really is whether the NIDS bill and the life certificates, can you please indicate if this bill makes provision for registration of person's debt to a person's NIDS ID? If this linkage is made, then the need to submit quarterly life certificates could be removed once the system is operating efficiently. I await a reply. Mr. Vernon, we have answered this before, but could you repeat the answer?
Okay, thank you, Chairman. So you're correct. We would have addressed this matter before, specifically concerning the use of the national identification card. And just to repeat that an individual that is registered in the national identification system, that individual birth record will be connected to the identification record. Therefore, once you register any civil event or any change in terms of the individual's identity on the civil register side, then identity will automatically, be aware of this change. Therefore, the card can be used for the verification of someone's identity and also to determine if the person is still alive.
Okay, thanks. The next one is from RV. It's a Gmail account. And a very quick, if we already have assigned a TRN number which sticks with you throughout our lives, why spend so much money on a new system? Just add photos which have to be updated at prefix intervals. Again, Mr. Vernon, just respond. Huh? Well, to be frank, we just want at least a member to know that we have got. It's clear to me that the TRN would not succeed. TRN is really for business purposes, companies of TRN, etc. So it would not be sufficient. The third one is from WB. From WB, good day, will biometric fingerprint be a part of NIDS component as also facial recognition? My understanding is that it is only fingerprint, name, addresses, and facial recognition. No other biometrics such as DNA, blood samples. These I've seen on social media. They are not required. No such biometric is actually being put together. The fourth one is from VDB. VDB from a Gmail. I'm of the views that this law, if enacted, would have given the government too much power to enslave the people of the land, in that all rights and freedoms to exercise one basic rights would be trampled on. The following are my concerns. The rights that we currently privilege would be taken away. Our privacy is likely to be envied by all internationally due to technology. Our fingerprints and blood samples would be a part of the process. A data bank is required by a state on one's personal activities. 4, the country is now ordering vaccines, which would appear to be linked to persons' identification. This would be a serious move by a country's government. 5, this NIDS bill is a downright backward system from South-North Korea that is used to control and manipulate as well as a dictatorship on the people. Having a system as this would see the country experiencing serious tailspin into slavery. Therefore, I'm not in agreement with the passing of this bill. A quick response, Mr. Vernon or your team. Yeah, obviously this has no merit, the argument. Okay, I think we can say, you agree, we don't need to respond to that. It's not true. There's no question of blood samples being taken, and it's quite clear to me that most of these are more misinformation. Sure. Sure. Well, what I would do in the future, and even now, members who have seen any that we need to respond to, I will just say we did get one from WT at Gmail. It should be gmail.com. I don't really think there's need to be a response. We have another one from, well, it says Rastafari, but and as you see, we want to thank Prophet Greg for his contribution, but I don't think it has to do with reparation and whether the NIDS would stop application for reparation.
You know, Mr. Chairman, sorry through you, I think it would be worth it to say that that Prophet Greg's concern and his question is whether the NIDS will obstruct the reparations movement in any way.
And the answer is no.
And the answer is no. So
Quite.
I think that is what he
wants
should be
to find
expressed,
out.
to
Okay.
know that there is nothing in the NIDS bill or in its intended implementation which will in any way impact any effort in respect of reparations. And it also...
and the potential breaches of human rights, no.
No,
there will
that
be no
every effort has been made to have it be as sensitive as possible.
Right.
And entirely compliant with the Constitution of Jamaica, even to the extent that there are persons who think that it has gone too far in the other direction in permissiveness. So we hope that Prophet Greg will hear is listening to the interventions and is hearing that his concerns
Quite.
Well, his concerns have been addressed.
Have been addressed. Thanks, Minister Kamina Smith. The seventh one is from TD at tdaily.sas. The question, her question is whether or not the financing of the NID Secretariat will be a burden, and how we ensure the best security possible for the information that have been retained. The answer is that the government is committed to NIDS, the NERA, that is the National Identification Registration System. It will be financed out of the Consolidated Fund, and that there will be every effort made to ensure that the data is properly protected.
Sorry to intervene, but this question, I think, is a question that I've heard raised in public, because people are of the knowledge that our initial effort comes from our collaboration with the IDB. But I think it may be important for us to outline shortly to persons the evolution of what NIDS will become in terms of the RGD and all of that, which will demonstrate to them, just as how we maintain a proper or relatively okay database of births and deaths, and that is funded effectively, that it's the same approach where it is the government sees it as a very important part of our national development.
Yes, you have said it well, Minister Morgan. So the RGD will be a part of the NIDS authority, and therefore even funds earned from the RGD will be a part of the funding of the NERA in the future. Wouldn't that be so, Mr. Vernon?
I would say yes, Chairman, based on policymakers' assertions, and also to earn funds from identity verification services.
Okay. The next one, a brief, is from MC Isaac 2 at Gmail. The concern is that too much sensitive, detailed data in the public domain, which can endanger the lives of citizens, prone to be hacked by the generation of boomer hackers, and too much private info required for an ID, cause of serious problem of identity theft. Just for information, what is on the data collected will not be available to the public at large, so that it is only accredited institutions can can verify information. And it is true that no data is 100% protected. All efforts will be made at every level to ensure that we overcome the hackers, including the boomer hackers, as was indicated. And the information collected is really simple information that is in the public domain of every registrant: name, address, date of birth, and the only additional information that may not be public would be fingerprint, because facial recognition, facial is in the public domain. So to say that too much information is really minimal information is being collected. Sorry, go ahead.
I think, Mr. Chairman, what is important to highlight is that there will be no information in the public domain, that the NIDS is not a public database in any event, it's not a public system, and it will in fact have the highest level of security. It's several layers of security protocols that are embedded, already being prepared in readiness for the system, and that counter to the person who has submitted this concern, which says that this will create a problem of identity theft, that is, that the NIDS will. It's the very opposite. It is those countries in which they don't have an identity system that captures biometrics, which have the largest incidence of identity theft, because the ID that they are in fact granted by their country is replicable, more easily replicable, because it is not linked to the single biometric or to any single biometric element which is unique to your person. So it is to assure him or her that this is actually intended to protect Jamaicans in the era of a digital age.
Thank you,
Chairman,
Minister.
could you,
Yes.
I think it would be valuable if Mr. Vernon could, in light of events of the last couple of weeks, give an overview of the security features of the NID system, what is in place, what the architecture is, because there are obviously public concerns which were expressed in this submission here.
I'm very interested to hear that as well, Mr. Chairman.
I'm not, and obviously I'm not asking
If
for
he is prepared to
very
do so.
technical details in your submission, but I think people have obviously expressed concerns and would want some reassurance about what you're putting in place to protect the data.
Mr. Chairman, I was asking off the mic. I hope you don't mind.
Sure.
I'm just saying that certainly the more that you share about your security architecture is the more that you share information that can be used by persons whose intentions are not well. So I'm saying your question is a legitimate question. And I am hoping that I'm trusting that Mr. Vernon will answer and provide an appropriate answer. But I'm also just indicating that I think that's sometimes when we think we are being helpful in a situation by asking certain questions, that we're in fact doing the opposite. But I know Mr. Vernon will find the right balance.
Go ahead, Mr. Vernon.
Okay, thank you, Chairman. So what I'm going to say first is really to set context, which is very important. I want to first indicate that, revealing the internal security controls of the NIDS would degrade the risk management controls incorporated into every process that we would have developed to date. Revealing information publicly about the PKI setup, data storage, data segregation, and security protocols are useful for an attacker. However, we can disclose our risk management standards to all parties. And I think the conversation here today ought to be about risk management in terms of our cyber resilience. So, having said that, it is important for the public to be aware that the national identification system, when implemented, will be compliant with the National Institute of Standards and Technology Cybersecurity Framework, a very strong cybersecurity framework. Additionally, some of the NIDS components will be compatible with the cybersecurity maturity model certification before production use. And just to say that the CMMC, this model, is a requirement for the U.S. Department of Defense contractors. And we are using all of those standards and processes from day one on the project. The security profile of the NIDS is completely different from other systems based on the people who are involved and the processes that we are following. From day one, when we started this project, we established a security and technical working group with 16 competent people from across government, and an additional 16 joined the team once the contract was awarded, where we have a number of international cybersecurity experts and e-identity experts working on it. We are going by standards. We are not saying that there are no risks. Every single system, we have risk connected. to those systems. But once you abide by the security standards, they will protect you. You will be one step ahead. And we are using those standards. In fact, we would have developed from day one our security guidelines. We refer to them in IT as acceptable security guidelines. And those are the guidelines, what we consider to be the Bible that our people are using every day to make decisions. And the ISO 2700 series set of standards for information security, and also COBIT 5. We depend a lot on COBIT 5 in terms of our governance and security by design. So, and just to dig a little bit deeper, for the public to benefit from this, we were always thinking about risk from day one. I recall when the committee met and we started defining the processes, and when we were finished and we went to tender and then moved to evaluate the bidders, the top 3 bidders, we immediately asked for and spent a lot of money to do a global scan, a due diligence report on all of the consortium members. We knew every single thing, about them and all of the risk before we got in. So we're managing risk from day one, because all of this is really about risk management. And once you abide by the standards, it is very unlikely that you are going to be in trouble. And so when you talk about security, you can have discussion about the inner workings and the technical details in the background, but those details ought not to be in a public forum. There may be a need to provide comfort, for the Parliament to consider some committee, maybe in a private setting, for persons to get more details about what is happening in the background for security. But certainly, outside of sharing the standards that you are using, you wouldn't be able to share in a public domain exactly what you're doing, because you'll be providing more details to an attacker, which really would put you in a position to be hacked. So, and when you look at the development of a system, you talk about software development life cycle, as technical people, we know that there are certain processes that you must follow by standard. And a very basic one, when you build a system, you start from user acceptance testing all the way down to stress test, and you do penetration test. All of those things must be done. And it is for this reason why I said some components of the NIDS, all of those critical components, will be CMMC certified, which is very, very important. And the certification is something that can't be done just one-off. It must be ongoing certification. There must be ongoing monitoring. And there's definitely a need. And I'm really happy for the conversation that is happening in the public domain, because we really need to have a national campaign to build awareness about cybersecurity for everybody, because we are already in this age, but there are a lot of persons who really don't understand the danger that is out there. And when you talk about cybersecurity and protecting individuals' information, it has to be a collective effort. And I remember Mr. Robbins said once that the government must have the primary role in all of this. But even though the government is playing the primary role as a data controller, then the people will also have to play another role in terms of not disclosing your personal information, and the tool that you will receive is to make sure that you protect that tool. So information security can be seen by some as very complex, and it can also be seen, depending on how you view it, in a simple way. But you see, we have to lift the conversation now from cybersecurity to talking about cyber resilience. How are we going to protect our national assets, from an attack? And there has to be, a process that, one would follow. But just in closing, to indicate again, is that we are abiding by strong international standards for every process that we are defining, every step of the way. And the people that are working on this project are competent people. We would have seen their work to date and see exactly what we're doing. But I believe that there will be a need to have some close discussion with, maybe with the opposition or maybe a committee of the parliament that really focus on national security so they can understand the inner details without us exposing this to the public.
Sure. In fact, may I suggest that when we're dealing with data protection and security, we may well go in camera with the Joint Select Committee so that some of the experts can give us some insight as to how data can be protected. Because it is a fact that cyber security and attacks are real problems. And I'm glad MOCA is here, and MOCA may well be one of the agencies that could make some submission to us, or at least assist the committee in feeling satisfied that we can protect and secure data to a very high degree, because it is a fact that the public at large is concerned about any data being hacked or being exposed, and the NID Secretariat will have to convince the committee, with the assistance of MOCA and other agencies, that enough will be done, that data will be secured and protected, okay? So that will come maybe after all these submissions. And a lot of these submissions coming to us, written, and also when we did the virtual town hall meeting, persons were very concerned about the protection of their data. What I can say from that, the committee is also concerned, and therefore the committee will seek further deliberations, probably in camera, to ensure that it is happy that enough safeguards will be put in place to protect data that is collected. Okay? Okay, members. Just one or two other points before we go. If we look at, I don't mind Dr. Alfred Sang's minding that I call his name, he put in a nice suggestion that the card, that's the NIDS card, should be very simple. And he's saying that the data that is put on the NIDS card should be minimized, because he says from reading the bill, you have too much data. You're suggesting too much data is going on the card that is being issued. That is number 18 in our list. So he is recommending that the card, a simpler card, it should be a small card. And there's no doubt that before we even, everything is rolled out, that the NID Secretariat will give some idea of what the card will look like. Isn't that so, Mr. Vernon?
Yes, that is correct, Chairman.
Right, thanks. Now, Marlon O. Sent in one, and he's saying that the NIDS bill should be made mandatory in the next 2 years. No contemplation at this time, I suspect. We have agreed that it is voluntary. The mandatory nature of the bill has been knocked down by the court, and we respect the court's position at this time. There's one from Sharon. Jarman Shaz, and it's an email. Sorry? No, okay, fine, yes. The concern of this person, that her husband and herself are very concerned that we are rushing this NIDS bill. May I just make the point that this NID identification has been discussed for the last 50 years. And certainly it's about time we make a decision. The couple is also concerned about the possibility of the data being stolen, and said that we should impose imprisonment rather than a fine, making it tougher and a tougher deterrent for ID theft and fingerprint, facial recognition, and so on. That is a matter that the committee will also look at in terms of increasing the penalties. And they're also concerned about the storage of the data, which is something that we are also examining, that the data should be properly protected, and indicating that scammers are very active, and in those circumstances, protection of the data is also important. And I can assure the couple that everything will be done to ensure that none of the data is exposed or released at all. I think we have gone through most of these. What we're going to do for the next session, we just summarize, the issues in most of these one-liners, okay? And then we take them. I think we have did about 15 of the 20. There are some longer ones which we can deal with at the next sitting. So members, we can break early because, as we had intimated, some of the presenters were not able to make it. But as I indicated, next Wednesday, we're going to meet here in Parliament and also virtually. I do hope some members can join us in Parliament, but if not, we will do it virtually. We're going to have some presenters who, again, we will have to make a determination if they can do it virtually or here in Parliament. We will so indicate by Monday or Tuesday, and then we're going to summarize many of these contributions that have been made to us and just highlight any issue. But at least once a submission comes in, we will at least say here that we got a letter from Sharon and therefore came in on such and such a date, so that person will know that the committee has these contributions and have read them. So if there are no other matter for this afternoon, any other business, can I have a motion for adjournment? So moved and seconded. All right.